Well, friends, the Supreme Court just threw Donald Trump and some of his fellow insurrectionists, his foot soldiers, a lifeline. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump's foot soldiers, the boots of the insurrection, the ones who were inspired and incited by Donald Trump's lies to attack the U.S. Capitol on January 6th. And why did they do it? To stop the certification, to stop the steal, or put another way, they attacked the Capitol to obstruct an official proceeding, the certification of Joe Biden's election win. And here's the thing. The law criminalizes expressly, in plain language, obstructing an official proceeding. But in a new Supreme Court opinion authored by Chief Justice Roberts, that plain language doesn't matter. And what a favor the Supreme Court just did for Donald Trump and some of his fellow insurrectionists. Now, at first, friends, this is going to feel a little dense, a little like we're down in the legal weeds, but please stick with me. I'm going to try to mow down those legal weeds and make it clear. We're going to start with the new reporting, and then we're going to look at just a little bit of this new Supreme Court opinion. First, the new reporting, this from NBC News. Headline, Supreme Court rules for January 6th rioter challenging obstruction charge. And that article begins, the Supreme Court on Friday ruled in favor of a former police officer, that's right, a defendant who was a former police officer who attacked the police on January 6th at Donald Trump's urging, trying to stop the certification. It's my angry editorial edition. The Supreme Court on Friday ruled in favor of a former police officer who is seeking to throw out an obstruction charge for joining the Capitol riot on January 6, 2021. The justices, in a 6-3 vote on non-ideological lines, handed a win to defendant Joseph Fisher, who was among hundreds of January 6 defendants, including former President Donald Trump, who have been charged with obstructing an official proceeding over the effort to prevent Congress's certification of President Joe Biden's election win. The court concluded that the law was only intended to apply to more limited circumstances involving forms of evidence tampering, not the much broader array of situations that prosecutors had claimed it covered. The provision targets anyone who obstructs, influences, or impedes any official proceeding or attempts to do so, but the court determined that its scope is limited by a preceding sentence in the statute referring to altering or destroying records. The court sent the case back to lower courts for further proceedings on whether the Justice Department could still prosecute Fisher under the new interpretation of the law. Attorney General Merrick Garland said in a statement that he was disappointed by the decision because of the impact it would have on the Justice Department's January 6 cases, although he stressed it would not affect the bulk of them. So friends, at least it's some small consolation that this court ruling will only impact a few dozen of the defendants among the more than 1,400 defendants who have been charged with January 6th related crimes. But now let's take a look at just a short passage of Chief Justice Roberts' opinion, the opinion that was authored by him, and then we're going to take a look at the law itself, so there is no confusing the actual words in the statute. But first, here is how the new Supreme Court opinion opens. The Sarbanes-Oxley Act of 2002, that's just the technical name of the law involved, imposes criminal liability on anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, with the intent to impair the object's integrity or availability for use in an official proceeding, and that's 18 United States Code Section 1512C1. We're going to refer to that as C1. That's the first part of the statute. Now we're going to move on to the second part, the relevant part of the statute. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, Section 1512C2. And we're going to refer to that as C2. That's the relevant part of the statute. And friends, just so there is no mistake or misunderstanding about the exact words in the law, that's the law that is found in, the big ugly blue book of federal laws, the United States Code, I'm going to put the actual text of the law up on the screen. So there is C1. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, that's one crime. Or let's move to the second crime, C2. Whoever corruptly, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so is guilty of obstructing an official proceeding. So friends, again, not to belabor the point, to violate C1, you need to mess with a document. But to violate C2, you don't. You just need to otherwise obstruct the proceedings, like, tying up members of Congress so they can't conduct the official proceeding, or nailing shut the committee hearing room doors so they can't access them, right? That would obstruct the proceeding. Doing the kind of stuff that Donald Trump's insurrectionists did on January 6th at his direction. Nevertheless, now that we have a clear, unambiguous understanding of the law, let's have a look at what Chief Justice Roberts concludes. Held, to prove a violation of C2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in an official proceeding or attempted to do so. Okay, Mr. Chief Justice, I don't see in Section C2 where it says you gotta mess with a document. In fact, let's look at it again together. It doesn't say it. It's not in there. But friends, don't take my word for it. You know who most pointedly and directly and compellingly told Chief Justice Roberts he's wrong? Justice Amy Coney Barrett, in her dissent, which was joined by Justices Kagan and Sotomayor. Let's have a look at that dissent. Justice Barrett, with whom Justice Sotomayor and Justice Kagan join, dissenting. Joseph Fisher, the defendant in the case, allegedly joined a mob of rioters that breached the Capitol on January 6, 2021. At the time, Congress was meeting in a joint session to certify the Electoral College results. The riot forced Congress to suspend the proceeding, delaying it for several hours. The court, meaning Chief Justice Roberts, the majority, the court does not dispute that Congress's joint session qualifies as an official proceeding, that rioters delayed the proceeding, or even that Fisher's alleged conduct, which includes trespassing and a physical confrontation with law enforcement was part of a successful effort to forcibly halt the certification of the election results. Given these premises, the case that Fisher can be tried for obstructing, influencing, or impeding an official proceeding seems open and shut. So why does the court hold otherwise? Because it simply cannot believe that Congress meant what it said. Section 1512C2 is a very broad provision, and admittedly, events like January 6th were not its target. Who could blame Congress for that failure of imagination? In other words, who in the world could ever have predicted that a president who just lost an election would command an angry mob to attack the Capitol to stop the certification of his election loss and his opponent's win? Who could blame Congress for that failure of imagination? But statutes often go further than the problem that inspired them. And under the rules of statutory interpretation, we, the justices, stick to the text anyway. The court, meaning the majority, abandoning that approach, does textual backflips to find some way, any way, to narrow the reach of subsection C2. I respectfully dissent. And Justice Coney Barrett then points out how Chief Justice Roberts uses some word games, twisting and contorting some rules of statutory construction, not to mention some rules of grammar, to reach his desired result. But she says that what he does is like using a hammer to pound a screw. It looks like it might work, but using it botches the job. Now, I'm going to jump to the end of her 15-page dissent. I urge you to read it, just as I urge you to read the majority opinion. And there's also a separate opinion, a concurrence by Justice Ketanji Brown Jackson. Please read through the whole thing so you can reach your own conclusions. But at the very end of her dissent, Justice Amy Coney Barrett sort of calls out, I would say exposes, what's really going on here. Here's what she says. There's no getting around it. Section 1512C2 is an expansive statute, yet Congress, not this court, weighs the pros and cons of whether a statute should sweep broadly or narrowly. Once Congress has set the outer bounds of liability, the executive branch, that would be the prosecutors, the executive branch has the discretion to select particular cases to prosecute within those boundaries. By atextually narrowing C2, the court has failed to respect the prerogatives of the political branches, the other two political branches. I respectfully dissent. I agree. Congress said what it meant what it said, and call me crazy, but Defendant Fisher and all of the other insurrectionists should be held accountable when they obstructed, influenced, or impeded that official proceeding on January 6th. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.